Many businesses fail not because the idea was flawed, but due to inadequate paperwork. Contracts are essential to any serious venture. They establish ownership, prevent disputes, and ensure that money flows appropriately. Neglecting them is akin to gambling with potential lawsuits, broken partnerships, and financial ruin. In this video, we'll outline the 5 contracts every entrepreneur must understand, documents that distinguish hobby projects from legitimate businesses. Chapter 1. Operating Agreement / Shareholders Agreement. If you're starting a business, one of the first contracts you need is an operating agreement if you form an LLC, or a shareholders agreement if you form a corporation. These documents serve as the blueprint for your business operations. They define ownership percentages, outline voting procedures, dictate profit distribution, and specify who has decision-making authority. They also address what happens if a partner wants to exit or if new investors wish to join. Another important aspect is capital contributions, and this refers to the money, property, or services each member or shareholder commits to the business. The agreement formalizes these contributions and may require additional funding down the line if necessary. Without clearly defined terms, one partner might feel they are bearing a heavier financial burden while another contributes less. The real danger of not having one of these agreements in place is that state default laws will automatically apply, and these laws often do not align with the founder's intentions. For instance, in some states, profits are divisible equally, even if one founder contributed 90% of the funds. This situation is a recipe for disaster. Imagine 2 partners. One invests capital while the other provides labor. Everything seems fine until the business becomes profitable. Suddenly, the investor demands more control. Without an agreement, this disagreement can escalate into a lawsuit. However, with one, the expectations are documented, thereby preventing conflicts from arising. Chapter 2. Employment and independent contractor agreements. Almost every entrepreneur employs individuals, and whether full-time employees or independent contractors. Here's the reality. Without comprehensive agreements, you're inviting lawsuits, tax issues, and endless complications. These contracts establish the fundamentals of how work is conducted, how people are compensated, and who owns the results produced. For employers, essential elements include specifying whether the job is at will or for a fixed term, defining roles and responsibilities, and setting performance expectations. A well-drafted agreement can reference an employee handbook or code of conduct to clarify expectations. Intellectual property ownership is another crucial aspect. Anything created during working hours should belong to the business, not the individual employee. Don't overlook confidentiality clauses and, where enforceable, non-compete or non-solicitation clauses. Lastly, be explicit about termination conditions. What qualifies as for cause and what procedures are followed if the relationship is ended without cause. For employees or contractors, the focus shifts. They should look for payment details, including the amount, frequency, and form of payment. Benefits are important too, including health insurance, retirement plans, and paid time off. Clear expectations around working hours, remote work options, and location are vital. Be cautious of clauses restricting secondary employment or side gigs. Non-compete and non-solicitation clauses may seem harmless, but they can severely limit job opportunities in the same field later on. The bottom line is straightforward. These agreements protect both parties. They prevent misunderstandings from escalating into disputes. While a handshake may seem friendly, nothing can replace a written contract when money and careers are at stake. Chapter 3. Non-disclosure agreements. At some point, every entrepreneur will need to share sensitive information, whether with investors, vendors, or potential partners. This is where a non-disclosure agreement, NDA, becomes essential. An NDA ensures that your confidential information remains protected and does not fall into the wrong hands. Clarity is key. A robust NDA clearly defines what constitutes confidential information and typically establishes a time limit of 2 to 3 years, although sometimes longer, depending on the industry. The agreement should outline what the other party is permitted to do with your information, such as reviewing a pitch deck is acceptable, but copying the business model to create a competing venture is not. However, NDAs are not foolproof protections. They cannot safeguard information that is already public, known to the other party, or independently discovered. Therefore, most agreements include specific exclusions. You will also need to decide whether the NDA will be unilateral or mutual. A unilateral NDA binds only one party, usually the investor or contractor receiving the confidential information. A mutual NDA binds both parties, making sense when two businesses are sharing sensitive information. Chapter 4. Loan and Promissory Note Agreements. Money is the driving force behind any business, and eventually every entrepreneur finds themselves dealing with loans. Whether these loans come from a bank, a private investor, or even family and friends. Loan agreements and promissory notes are crucial. They transform vague promises into clear obligations. These agreements outline key elements such as repayment terms, interest rates, collateral, and the consequences if the borrower fails to repay. Having a proper note eliminates confusion about payment due dates and outstanding amounts. For lenders, these documents offer protection, while for borrowers, they provide clarity. Additionally, formal notes and loan documents reflect a well-structured business, indicating that it is properly financed rather than being casually managed. This can have a significant impact during audits, tax reviews, or future fundraising efforts. If investors see that your financial relationships are documented and handled professionally, it positions your operation as serious and credible. Consider a scenario where a friend lends you $50,000 to start your business. If, years later, after your company has become successful, they claim you promised them a 20% ownership stake, the absence of a promissory note clarifying that it was a loan and not equity could lead to a legal dispute. Furthermore, UCC filings determine the order of payment in the event the business fails. A lender with a properly documented note and security interest will always have priority over someone relying on a vague promise. Ultimately, promissory notes serve as proof. They protect relationships, prevent disputes, and keep your business grounded during financial transactions. Bonus chapter: Commercial Lease Agreements. If your business operates from a physical location, such as a storefront, office, or warehouse, your commercial lease is one of the most critical contracts you'll ever sign. Often, a lease can outlast your business plan. Signing a poorly structured lease can jeopardize your company, even if sales are strong. Key clauses to carefully review include rent structure, renewal options, subleasing rights, and maintenance obligations. Some leases contain personal guarantees, meaning that the landlord can pursue you personally if the business fails to pay rent. This is a risk every entrepreneur should assess thoroughly. Be mindful of any CAM charges, which are common area maintenance fees. These charges cover expenses related to shared spaces, such as parking lots, hallways, or landscaping. However, landlords may inflate these fees. A lease that initially appears affordable can become burdensome when hidden costs appear in the fine print. Renewal options are also important. Securing fair renewal terms provides your business with stability. Without these options, a landlord could unfairly increase your rent just as your business gains momentum, forcing you to relocate and potentially lose customers. The reality is that a commercial lease can derail a profitable business faster than poor sales can. I have witnessed companies that seem financially strong but fail because rent and associated fees consume their profits. Therefore, negotiating favorable lease terms from the outset is essential. While the lease may not seem glamorous, it ultimately determines whether your physical establishment thrives or crumbles under hidden expenses. In business, these contracts are essential. They not only mitigate risk, but also establish clear expectations, protect relationships, and provide the structure needed for your company to grow. Ignoring these agreements puts you at the mercy of chance. Utilizing them lays a strong foundation capable of withstanding disputes, financial challenges, and even unexpected success. Thank you for joining us today at Due Process Daily. If you found this helpful, please give us a like and consider subscribing to our channel to support our growth.